Coast. Welcome to the first webinar of 2020 for ACCSE. We have a really big turnout today, so I'm going to take a minute to allow the system to populate. We had over 755 registrations for our webinar today, so really excited with that turnout. We have such an important topic to cover today. So this would be a good time for you to settle in. Check your video, check your audio, get comfortable. We're going to go just about an hour today. And again, we're just allowing the system to populate for a couple of minutes. It's 2 o'clock on the East Coast here. It's 11 o'clock on the West Coast where Christine and Vusala are coming to us from. And again, welcome to the webinar. We'll get started in just another 30 seconds, and we'll go over some logistics before we dive into the Title IX webinar this afternoon. So thank you for being here with us today. We'll go ahead and get started here in just about 30 seconds. So right now we have about 386 folks. That number is going up. We're expecting about 750, so just another 30 seconds for us. But thank you for being here for the ACCSE webinar. Okay, well, we'll go about another 10 more seconds. You should be settled in. We're getting ready to start the webinar. Let me go ahead and pop in and say hello to everyone. Hi there, my name is Christopher Lambert. I am ACCSE's Executive Director, and I am going to be your moderator for today's webinar, hashtag #MeToo, Title IX for Non-Traditional Schools. Really excited to have such a strong turnout today for the ACCSE webinar. Again, over 755 registrations. Looks like our system is populating. We have over 412 people joining us so far. So we're just spending a couple minutes here at the beginning to allow people to log in and get settled in for the start of the webinar. But again, appreciate everyone taking the time to join us. I will be moderating today's session. While people are logging in, let's go ahead and talk a little bit about logistics with the webinar. I want to share with you a little bit about the tools. But first of all, in your toolbox, you will see a handout section, and there are a couple of things in the handout section for you, including a copy of the presentation, a sign-in sheet that can be used for documenting participation in today's webinar, as well as certificates of attendance. Now, if you registered for the webinar under your email address, the system is automatically going to send you one certificate of completion. But for many of our schools, they're taking the time to get together and watch this as a group. And so we've uploaded a customizable certificate in the system that you can download. And again, you can customize and keep that on record, along with the sign-in sheet that would serve as great documentation for participation in today's session. We're going to do some live polling today as well. So you can see in your toolbar that we have a polling tool, and at some point later on, we're going to launch some polls to give you a chance to weigh in. And then we'll have an opportunity to answer some questions as well. And you can see that there is a chat function and some question functions as well. So if you have a question, feel free to use those tools, and we'll do our best to get you the guidance that you need. So that's a little bit about the toolbox, a little bit about the logistics. So let's go ahead, and I'm going to pop back out. I will see you at the end of the webinar, and let's go ahead and start with our introduction. So thanks again for being here on such an important topic, and I will be jumping back in just a little bit later. So thanks. Okay, well, I'm really excited to be the moderator for today's session. Over the past few weeks, I've had a chance to meet with Christine and Vusala to plan for today's session, to talk a lot about Title IX. It's been really an interesting experience for me. As I've shared with our two panelists, I see Title IX everywhere. Almost every day it's coming up as part of conversations here at ACCSE, as part of reauthorization of the Higher Education Act, and it's such a timely and such a critical topic that I'm just so thankful to have Christine and Vusala with us. So Christine Galston has over 20 years of higher education experience providing compliance, regulatory, and Title IX support to a diverse range of post-secondary institutions, including a number of schools accredited by ACCSE. Currently, Christine provides legal and consulting services to institutions with a focus on Title IX, and she serves as a T9 investigator, an adjudicator, and appeal panel member, as well as in mediation and other forms of conflict resolution. Christine is very proactive with T9 compliance, including training program development and delivery, as well as P&P review and development. So really excited to have Christine join us here today. And joining Christine on the panel is Vusala Aranjo. Vusala is in her current role at Gemological Institute of America, an ACCSE accredited institution. She is the Manager of Education Compliance and is the designated Title IX and 504 ADA coordinator. In this capacity, Vusala is responsible for oversight of matters related to continued compliance with accreditation standards, regulatory requirements, and oversees GIA's compliance with Title IX and 504 ADA laws. Vusala brings over 10 years of higher education experience to our session today. She's an ACCSE certified accreditation professional. She's a certified compliance and ethics professional, and she's an ATIXA certified Title IX coordinator and investigator. Despite all of those activities, she still finds time to volunteer with ACCSE. So I'm very thankful and appreciative to have Christine and Vusala join us today. Let me go ahead and turn things over to them. So thank you, ladies.
Thank you. Good morning, good afternoon to everybody who's joining us today. This is Vusala speaking. Christine and I are so excited to have you to be with us today for the next hour or so. And this is definitely, like Chris said and kindly introduced us, it is definitely an important topic. And it's not a light topic, but we will try to find a way to share the information that we have with you so that you can take it back to your staff, to your students, and find the ways to manage this particular law or manage this particular compliance aspect of Title IX at your institution. And then just before we move on to anything else, Christine and I will do our best to answer your questions, but please know that every school is very unique, every situation is very unique. If you do have a specific question that we are not able to answer, it's probably best for you to contact someone, an attorney or a consultant, to be able to help you to address your concern. And that said, you know, Title IX obviously been around for quite some time. It is a complex web of regulations that comes with it. But really for us as ACCSE schools, it's important to start with the foundation of what we do, foundation of who we are as a school, and then what do we want to offer to our students? What do we want to offer to our community? And then most of us, I do at least, right? Most of us wake up in the morning with the best of intentions. We wake up and we want to come to work, do our best, give our best to our students, give our best to our colleagues, and that sets the foundation of integrity. Once we have that foundation, all the laws, all the regulations that exist out there, even though they're complex and they're difficult sometimes to even comprehend, it becomes slightly easier for us to understand how much of it is applicable to us, and then how much of it we can manage with the resources, with the capabilities that we have at our institution. But yeah, I think the foundation, the floor, is integrity. And that's what Title IX law is asking too, right? The law itself is pretty simple. All it says that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or subjected to discrimination under the education program or activity that receives the federal financial assistance. So Title IX right there sets the floor for us, and we as the ACCSE institutions or just education providers, we want to reach for the ceiling. Now, why are we talking about Me Too? What does that got to do with anything? Most of you are probably familiar with these faces. But when Christine and I were doing this particular presentation at the PDC, right before the presentation, a gentleman walked up to me and asked, well, what is Me Too? And he actually followed immediately with the question saying, what is Title IX? Do I need to stay for this presentation? So I followed up and immediately asked him, well, do you run a school? Do you operate a school? Do you have students? Do you have staff? And his answer to all of those obviously was yes. And most importantly, do your programs receive Title IV funding? And again, his answer was yes. So I said, I think you should stay. Then you should stay, and you probably could benefit from some of these slides, from some of this information. And he did, and I think he enjoyed it very much. But Me Too, historically speaking, has been around since 2006. It was actually created by civil rights activist Tarana Burke. And in 2006, not a lot of people knew about it. It only took a life of its own in 2017, more than a decade later, when high-profile actresses or actors came forward and then claimed that Hollywood producer Harvey Weinstein sexually harassed them. And then so right there, the hashtag MeToo became a movement. It took the world by a storm. And it wasn't just celebrities, it was TV characters, and then many, many people joined the movement. And then many of the people that joined the movement claimed that at some point they've been sexually harassed. And the person who was responsible for that spark of the movement, Harvey Weinstein himself, he was found guilty last Monday. And he was found guilty for rape and felony sex crime. And I think a lot of the Me Too people that were affected by Me Too or were sexually harassed found some sort of indication or some sort of justice in what had taken place. Now, what's interesting is Me Too almost seemed like a phenomenon, right? Everybody kept talking about it. It was all over the TV. But for institutions of higher ed, the concept of Me Too or concept of sexual harassment has existed for a long time. And the institutions of higher education have been dealing with this for decades. Title IX itself, the law itself, has been around since 1972. And for higher ed institutions, things became a little bit hotter, a little bit more complicated when in 2011, the Obama administration issued the Dear Colleague letter. So that Dear Colleague letter create a brand new wave of whatever you want to call it, right? Stress or regulations or requirements or policy process changes. People have to, or the schools have to come up with a very quick method of addressing the claims of sexual harassment, complaints of sexual harassment. And then that process was complex, right? It required very specified way of handling the harassment, handling the complaint, handling the investigation. Of course, very complex way of documenting the complaints that came in. And so now what does that mean for us, the ACCSC schools? If we just go back to what the ACCSC says, and then we focus on just the standards themselves, the standard IA2, right? And it says compliance with accrediting standards and applicable federal, state, and local requirements. And ACCSC kind of leaves it at that, right? That's really, we talked about the floor, right? Title IX sets the floor and we reach for the ceiling. Right there, ACCSC sets the floor for us. And it says, you must follow the federal guidelines. You must follow your local state guidelines. And some of our schools have locations or campuses in more than one state. And then you probably very familiar with the difference and the intricacies of each state regulation and how your processes have to match. For us, some of our policies are very different. We have campuses in New York and Carlsbad, and then some of our policies have to be different because the state requirements are different. And then so you, are, of course, are familiar with that too. We added that second standard on the bottom that basically what it's asking for, at least in the context of Title IX, your financial structure has to be sound. And then if we wind up being a school that has to handle a lot of concerns, a lot of complaints, dealing with state regulators, dealing with the Department of Education, that's a drain on our resources. And when our resources are drained, then our financial structure is no longer strong. And then it impacts everything across the board. It impacts everybody involved in the picture, the staff, the students, and then overall health of your organization. And so before we move on, let's talk about what is a non-traditional school, because this question was asked at the PDC as well. And I'd like us to do some polls. And then we have some poll questions for you, and Chris will jump in, and then I think you will be able to see it on your screen in a moment. And it just to get the feel of the room, right? We're not seeing each other, but it would be great to see who's attending and then what kind of schools we have.
Right, so I can see our folks are weighing in and voting on their school size. I'm going to keep this poll open for just another minute or so. Looks like we got about 71% of the folks. All right, I'm going to go ahead and close this first poll. There we go. So our first poll question, what is your school's approximate student population at any given time? It looks like most of the schools, almost half of our participants today, are at 250 students, about a third around 500, about 14% at 50 or less, and 3% at 5,000 or more. We'll go through. We'll do our second poll for folks. Hide that. Our second poll. Does your school offer the following programs or services? Athletics, residence halls, Greek life, combination of some of those services, or none at all? Given schools a chance to weigh in, we're about 65% voted. Go another 5 seconds. Close our poll and we'll share our results. So overwhelmingly, and not by surprise, most of the ACCSE membership are not destination schools that have dormitories and Greek life and athletic programs. Typically, they are career-focused that are offering the necessary training and skills to allow students to graduate, to pass certification exams, and to enter into the workforce. So not a big surprise by those types of services that are offered by ACCSE accredited institutions. And then here's an interesting question for folks. Does your school have a separate budget item for Title IX purposes? This will be an interesting question for folks.
And you don't want to answer, it's totally fine too.
And yeah,
it's not supposed to be.
We're not going to circle back on anyone and say, why not? What's going on at your school?
Right. It's not supposed to be a trick question.
Right. So let's take a look at where folks are at with respect to their Title IX budget. I'll share those poll results, and 63% of the schools of about 515 participants today do not have a separate Title IX budget, and 29% of the schools have Title IX wrapped into something else as part of their budgeting item. And one more poll question for folks today. This will be an interesting one. Do you have a designated Title IX coordinator? Let's see what folks are saying. We're at about 60% voted. Go just a couple more seconds here. All right, everybody's voted. We'll close this. Let's share that. And it's, well, great. 79% of participants on today's webinar have a designated Title IX coordinator. So that's great. So those are our 4 poll questions, Vasala and Christine.
Thank you very much, Chris. I appreciate that. Those are, like Chris said, I'm not surprised to hear any of this information, and I think it's maybe, hopefully you find this helpful, because basically we're all on the same boat here, right? We're all doing what we do best. We're career technical schools. We don't have dormitories. Most of us, we don't have athletics programs. We don't have any really extracurricular activities that require a special unit, a special separate building, or anything of that sort. So we just focus on education only. And about not having a separate budget item for Title IX, it's not unusual. In fact, I think it makes sense for our types of schools to incorporate that into something else, because again, talking about resources, talking about some of our schools have 3 staff members as administrators. There's no way to be able to even consider having a separate budget item like that. We're focused on just making sure that our educational programs are solid, making sure that our facilities are solid, and then so on. But I'm very excited, and I must admit, I am surprised to see the 79% for having designated Title IX coordinators. That's fantastic, because that is the law. That is actually the requirement, and it takes us back to the 2011 Dear Colleague letter, which specifically asked that the schools designate at least one individual who's responsible for managing, overseeing Title IX compliance. Now, here's our beautiful ACCSC schools. They, all of that said, at the end of the day, and we'll talk about it in a moment, our students come to our schools to get the education. And then we as school administrators and academic teams, we are responsible to deliver that to them. Now, what Title IX focuses on is making sure that the schools that receive the Title IV funding, any programs that receive Title IV funding, and all the programs that receive Title IV funding, they must abide by the Title IX laws, right? And then Title IX law and then regulations, and then what you see in the slide, it's not just the law itself, and there's also the regulations that go with it. There's state regulations that add another layer of complexity to it. There's case laws, and then each state, sometimes the district, at the district level, decides something else completely different than what our general understanding is of the laws. And of course, CLARIA and VAWA, we cannot talk about Title IX without talking about CLARIA and VAWA, which we'll touch on in a little while. And then the Title VII, which is the employment law, focuses on, again, sexual harassment and discrimination in the workplace. So when we look at this web of different requirements that exist out there, some schools or some organizations, they get overwhelmed. It is overwhelming, and it requires just sitting down, not more than one person sitting down and then putting their heads together and understanding the laws, and then understanding the applicability, and then understanding where the gaps are in our processes. Where do we have to change, make an immediate change to be compliant? And then I'll hand it to Christine now, who will focus on the current state of the Title IX, but also take us to where a lot of conversations are happening with the proposed Title IX regulations.
Right, thank you, Vasala. So I am really going to zero in on some very, practical considerations. Where are we today? What are the rules you need to follow today? And what can you anticipate under the new regulations, which we anticipate being released imminently any day now, although that rumor has been circulating for some time. So, as Vasala just mentioned, there is sort of this whole web of various laws, and there is a lot of media attention. This is a huge issue that can be, again, very confusing and overwhelming. And I'm going to try as much as I can to try to simplify it. So keep in mind that this is really going to be an overview. I'm not going to go into every detail of Title IX. And of course, when I'm talking about the proposed rules, they are proposed, they are not currently in effect. So keep all of that in mind. So to try to clarify potentially some of the confusion, where we are today is really in a transition phase as far as Title IX is concerned. As Busala had mentioned, Title IX, as it applies in the context of educational institutions, really became a big issue, an area of attention under the Obama administration. They released significant guidance that addressed expectations for schools, and their focus during that administration was a lot of attention on the issue of sexual harassment specifically, and sexual misconduct, including assault and sexual violence as types of sexual harassment. So that was really the emphasis under the Obama administration, and they developed a lot of guidance. This is sub-regulatory guidance. It's not law, although obviously schools are risk averse and they want to be compliant and they don't want enforcement action, so they are going to follow the guidance that the administration is promulgating. So when the Trump administration took over, they essentially set about really recalibrating Title IX. They felt that it had become overly expansive and that the method that it was being implemented across the nation at different schools was inconsistent and lacked sort of fundamental fairness, particularly for accused students. So they came into office, and in September of 2017, they withdrew some of the most significant guidance that had been issued under the Obama administration, and they issued their own guidance. At the same time, they announced that they intended to pretty much overhaul the Title IX regulations, which hadn't been changed since they were initially adopted in 1975. So from 1975 to date, the regulations hadn't changed, but there had been all of this activity in the form of judicial decisions, court cases, and guidance that was coming out of the department that was really shaping Title IX as it evolved, but it wasn't really reflected necessarily explicitly in the law. So they wanted to change that by rewriting the regulations. So they issued their proposed regulations, I'm sure as everybody knows, in November of 2018. And as I just alluded to, we are anticipating release of the final regulations any day. It seems like that rumor has been circulating now for a few months, and it seems like that sort of anticipated date keeps getting pushed back. But the most recent information that I've heard, and there are a lot of professional organizations tracking this, is that the final regulations could be released next week, but we will see. So you want to move the slide for me? Thank you very much. So just very high level, very quickly, what is the current law? What are the key features of the current guidance? If you're feeling confused and overwhelmed, go to the guidance that is actually in effect and exists today, and it's outlined specifically on that prior slide. But what does it do? Again, the emphasis is on ensuring fairness for all parties, ensuring there is no bias in the process, and many of the changes in the guidance and, of course, in the proposed regs that we anticipate are really undergirded by this belief or this principle that we needed to make changes to adjust the Title IX enforcement and activity on campuses to ensure that fundamental fairness was protected and that due process protections were in place. So that's a big part of the changes that are in place now and that we anticipate. In terms of concrete changes that are currently in place now, when the department issued their guidance in 2017, they allowed schools the option of utilizing a clear and convincing standard of evidence versus the preponderance evidence, which had been in place prior to that. So it just offers schools greater flexibility in determining how they want to adjudicate these Title IX cases and what standard of evidence they want to utilize, which is a good thing. We like flexibility. The current guidance also places an emphasis on, again, flexibility for institutions, and one way of allowing that is to encourage and allow informal resolution as a way of resolving and addressing Title IX issues. And specifically, under the prior guidance, mediation specifically was disallowed as a method of resolving complaints. But under the current guidance, it is allowed explicitly when appropriate. And then another concrete change that is currently in place from the prior guidance is relates to an appeal. And currently, if a school does not have to offer an appeal, that is their choice. But if they do offer an appeal, they have to offer it equally to both parties. Next slide. All right, so let's get down to brass tacks and talk about the proposed rule. This is just an overview. Again, as I mentioned, it is sort of recalibrating what the department felt was an overly broad definition and application of what fell under Title IX and what was actionable under Title IX. So the new rule explicitly includes a definition of sexual harassment, which actually wasn't even in the rule and hasn't been addressed in the rule, even though Title IX has expanded greatly, and that's become one of the primary focuses for schools is dealing with sexual harassment and misconduct on campus. So what the new rule does is it actually defines it, and it defines it in a much narrower fashion. In addition to that, the proposed rule, again, narrows the type of conduct that is actionable under Title IX. They narrow the situations under which the school has an obligation to respond. In addition to that, the new rules set forth pretty clear expectations for what the department wants to see from schools. One of the concerns of the department and complaints from others, just sort of in the broader sphere, was that the Title IX requirements were ambiguous and confusing and complex, and so the new regulations articulate, I think, pretty clearly what is expected of schools, and it also establishes pretty clear standards in terms of what does the department expect in terms of compliance, and when would a school be considered to be out of compliance with the rules. So it establishes a level of certainty for schools. And again, a very heavy emphasis on ensuring that application of the Title IX processes in schools affords fundamental fairness to all parties. And another sort of significant component of the rule, or the proposed rule, is that it aligns in many, many ways with current case law. So the standards that are in place in terms of potential liability for a school aligns with the standards that have been established by courts in civil litigation. And there are a number of examples where the department has borrowed from the Supreme Court precedent in establishing the standards for Title IX under the new regs. Okay, next slide. So, as I mentioned, one of the most significant changes of the proposed rule is that it includes a definition of sexual harassment. While sexual harassment was a major focus of schools in their enforcement of Title IX, it wasn't actually defined in the law. The original statute, the original Title IX statute, was of course focused on discrimination, and it still is. But as I mentioned, it expanded over time to include sexual harassment and other types of sexual misconduct. So the current regulations actually define sexual harassment, and they do so in a way that is a really very significant contraction or narrowing of what type of sexual harassment is actionable under the law. And the new definition of sexual harassment is really broken into, or it is broken into three pieces. The first is quid pro quo, and that is essentially when, a school employee is conditioning an educational benefit based on a person's participation in some sort of unwelcome sexual conduct. That one's relatively straightforward. That's one that we've dealt with in both the employment context. There's not a big change there. Where the change really comes into play is this next portion of the definition, which is sexual harassment is unwelcome conduct on the basis of sex that is so severe, pervasive, and objectively offensive that it denies a person equal access to education. And there are a number of sort of considerations or components to this portion of the definition. One is first of all, it lowers the bar, I guess, or raises the bar rather, in terms of what is considered sexual harassment. The behavior or conduct has to be severe, pervasive, and objectively offensive. And this is a standard that is borrowed. It's pulled pretty much verbatim from Supreme Court precedent, the Davis decision, which some of you may be familiar with. Another component of this is not only does it have to be severe, pervasive, and offensive, but that severe, pervasive, and offensive conduct must operate to deny a person access to their education. So it's really a two-part requirement there. And then lastly, the sexual harassment is defined in the new regulation to include sexual assault, the crime, as that crime is defined in Clery. So sexual harassment, again, had really expanded to include all sorts of sexual misconduct. And the department is really narrowing the type of sexual misconduct that falls within the definition of sexual harassment to the crime of sexual assault. And when you take, if you could go back. If you take these three elements together, this definition essentially limits the actionable conduct that is, again, actionable under Title IX to objectively serious behavior that, if left unaddressed, would jeopardize the student's access to education. Now, institutions are certainly free to establish higher, more stringent requirements in their codes of conduct, and the department, has made a point of sort of reinforcing that point, that although the regulations that sort of establish actionable conduct under Title IX that is considered discrimination under that law, that doesn't prohibit a school from having code of conduct requirements that are different or more expansive. So schools can address behavior that they feel is inappropriate that may not be covered within the new definition of sexual harassment or within the narrowing parameters of the Title IX regulations. All right, new slide. So related to this new definition of sexual harassment and how it really contracts the school's obligation to act, there are other elements that also must be in place, again, that trigger a school's obligation to respond. So as the threshold matters we just mentioned, the conduct has to meet this new definition of sexual harassment. But then in addition to that, the school is only obligated to act if it has actual knowledge of the conduct. And this is also a very big change from prior guidance, and which allowed constructive knowledge. And this actual knowledge requirement is, again, aligned with civil law and case law. And the department, their reasoning behind this is essentially, very simplistically, it's not fair to hold a school accountable if they don't actually know of the conduct which they have a responsibility to address. So that's a big change. In terms of actual knowledge, what does that mean exactly? The regulations define what constitutes actual knowledge as if a report or complaint comes in to an official with authority to take corrective action, that's considered actual knowledge. And then, of course, in addition, if an individual makes a report directly to a Title IX coordinator, that is certainly considered actual knowledge. It's not entirely clear what the department will consider to be an official with authority to take corrective action, but it's certainly a narrower group of individuals than the prior guidance contemplated. And again, that specific phraseology or that specific group of individuals is borrowed, again, directly from case law. In addition to determining whether the conduct meets this new definition of sexual harassment, whether the school has actual knowledge, the regulations also clarify that Title IX applies only to conduct that occurs within the school's own program or activity. The department, in their sort of commentary to the proposed regulations, doesn't really provide a concrete answer to what exactly that means. They say it's really to be determined on a fact, case by case and a fact specific basis, but that only conduct, again, occurring within the school's program activity is covered. And also they clarify that it applies only to U.S. persons. So if a school has study abroad, that is not covered under Title IX. Based on our poll results, I'm guessing that we don't have a lot of schools that have study abroad programs, but that is another clarification that the new regulations make. All right, moving on. And I'm looking at the clock here, and I want to make sure that we have enough time to get through the entire presentation. So I may start to speed up just a little bit here. So forgive me again, this is going to be high-level summary. So getting back to what the new regulations require in terms of how a school must respond, there's really sort of two categories here. And these are really important because, very simplistically and simply, if a school responds in these two manners, they will be deemed to have operated in compliance with Title IX. These are considered safe harbors. So the school does one of these two things as outlined in the regulations, they can take advantage of safe harbor, and they will not be second guessed by OCR or the Department in Enforcement Action. So first and foremost, schools are required to respond to all reports of sexual harassment. And again, that sexual harassment is defined by the new regulation, so it's narrowed. A report is differentiated from a complaint. So the regulations make it very clear that there are reports that require a certain response, and then there are formal complaints which require another response. So and really for all complaints, or all reports, I should say, the department and the regulations emphasize that supportive measures are really important, and supportive measures should be implemented to ensure that the reporting party and both parties, actually, because supportive measures need to be made available to both parties, that they are able to continue their educational program without interruption or distraction. And they feel that supportive measures are typically, in many situations a better means of accomplishing that. So again, any report of sexual harassment, supportive measures, which I'm going to talk about a little bit more in a minute, are going to be your go-to response. Now, if an individual makes a report of sexual harassment, they may also sort of elevate or escalate that report to a formal complaint. And a formal complaint will trigger application of the school's grievance process. And the grievance process that is required is outlined in detail in the regulations, which we'll talk about in a minute. But when a school gets a formal complaint of sexual harassment, they must follow their grievance process. A formal complaint has to be in writing. It has to be signed by the reporting party, or the Title IX coordinator themselves can make a formal complaint. So it's only under those two conditions, when a complaint is considered formal, that triggers the grievance process. All right, next slide. So supportive measures are really important because, as I just mentioned, there's sort of two buckets. There are reports of sexual harassment and there are formal complaints of sexual harassment. If a school implements supportive measures sufficient to ensure that the student has continued access to their education, they will be deemed to have complied with Title IX. So it's a safe harbor, really. So it's really important as a school to ensure that your organization is positioned to provide these supportive services and these supportive measures. And there's lots of different types of supportive measures. And of course, the particular facts and circumstances of the incident or the matter is going to determine what's a reasonable supportive measure. But this is an expectation of the department that when you get a report of sexual harassment, you're going to respond by providing supportive measures. And what are they? They are individualized services that are meant to protect the parties, deter harassment, and maintain access to education. Again, these are applied in all cases, whether or not there's a formal complaint or formal investigation. They must be free, no cost to the parties. They cannot be punitive, and they must be non-disciplinary. They need to be made equally available to both parties. And again, if you implement supportive measures in this manner, it will demonstrate that your response to a Title IX report is not unreasonable. So again, very important to keep that in mind. All right, next slide. Okay, grievance procedures. This is the other sort of bucket in terms of the specific response that is required by a school if they receive a formal complaint, and that formal complaint, again, falls within the definition of a sexual harassment and meets the other requirements to be within the scope of actionable conduct under Title IX. And the grievance procedures are all undergirded by a desire to ensure that students are treated equitably, that there is a consistency to the process, and most importantly, that the due process rights of the parties and the accused are respected. So the grievance procedures, I was going to go back to this real quick. The grievance procedures, if you haven't already, definitely need to go in and review the proposed regulations. And they articulate, I think, in pretty clear detail exactly what is required. I've got a few of the significant elements here on the screen. In addition, schools have to provide notice to the parties that meet certain requirements. There are a number of other detailed requirements that are articulated in the regs that I don't have here. So please make sure that you've familiarized yourself with those. Now, again, caveat, we don't know if all of these elements of the proposed rules will make their way into the final rules, but more likely than not, if they don't all, many of them probably will, because this goes to the heart of the department's concern that these processes be fair and equitable to all parties. I'm not, unfortunately, I had hoped to really go into a little more detail about these different requirements, but I think I'm going to move forward because I think I'm getting pretty long-winded here and I see the clock ticking. So let's go ahead and move to the next screen and talk about what represents probably the biggest and definitely the most controversial change to the required grievance procedures that are contained and addressed in the new regulations. And that is the requirement that institutions must provide a live hearing and that they must allow the parties to cross-examine each other and any witnesses. Real quick, the features of that include that the cross-examination has to be conducted by the party's advisor of choice, so that you don't get into a situation where the accused is directly confronting the complainant, which could be obviously problematic and re-traumatizing and all of that. So it has to be conducted by an advisor. And this is interesting because it really puts a massive burden, I think, on schools. If a party doesn't have an advisor, the school must provide one to them. And the advisor that is provided needs to be sort of on the same basis as the advisor of the other party to the matter, so that if the other party has an attorney, then the school has to provide one to the party without an advisor, which is a really interesting requirement. It will remains to be seen whether or not this one is going to make its way into the final regs. The requirement of providing a live hearing and cross-examination does allow for the cross-examination to occur in different rooms, so that the individuals and the parties are not sort of directly physically in the same space as each other, which could obviously be intimidating. So you can use technology to hold the hearing with the parties in separate rooms. And to further protect the victims or accusers, evidence of the complainant's sexual behavior isn't allowed, except obviously as it relates to the specific conduct at issue. All right, moving along. So I wanted to just very briefly remind everyone that in addition to Title IX and everything that we just talked about, there are many states that have their own statutes and laws that are aimed at addressing, sexual misconduct on campus. And in some cases, those requirements can be more stringent and different from what is required under Title IX. A couple of examples are New York State has a law called Enough is Enough. California has a law called Yes Means Yes. And both of these, and there may very well be other states that have similar type laws. And in fact, there may be other states that are passing or will pass other types of legislation or related types of legislation in light of these regulations to address what they see as laxity. So just make sure that as you're evaluating Title IX and your responsibilities and developing your policies and procedures, that you are aware of state law requirements. Many of them require a affirmative consent. They may have a different standard of evidence. For example, both the California and New York law require preponderance, although the new regs allow clear and convincing. and the new guidance allows clear and convincing, state laws may require the preponderance standard. They may have different training and other requirements, and they may have different, specific requirements with regard to your processes, your grievance process, and so forth. So make sure that you are aware of any state law requirements that may impact your school. All right. Next slide. Okay. I don't know about you guys, but this is sort of how I feel at the moment after kind of racing through that summary of Title IX. But we did want to take a minute here to give everybody a chance to ask questions. It's a large group, so we're going to sort of try to find some questions maybe that are representative of the similar questions. So I think our moderator, Chris.
Yeah. Well, thanks so much, Christine, for a really comprehensive overview of just a really complex topic. It's interesting to me the way that WSALA set it up, under the federal requirements, also, the expectation of accreditors. But, my experience has been in working with all of our institutions, 650 institutions across the country, that we have a shared goal, and that is we want our schools to be a safe place, a place of learning, a place where students are comfortable, a place where, we can foster innovation and we can help students to achieve their hopes and their dreams. And, I don't know if we ever spend the time that's necessary to talk about what happens when something like sexual harassment or sexual assaults occurs at my school. And so I feel like having these conversations is just so critically important. I know that for me, as quite frankly, for me as a man, it makes me uncomfortable, but I know that, as WSALA kind of set things up for our society today, that in order for us to really tackle this critical issue, we have to be open to having these uncomfortable conversations. And so I really appreciate setting that up, and as well as, making sure that schools are aware that things are in flux right now, and that there is guidance that's going to be coming down that's going to help them to kind of shape their Title IX responsibilities going forward. So thank you for that. That was really helpful, I think, for me to hear all of that today. Christine, one of the questions that came up, you mentioned that the Title IX regulations impact U.S. students. If a student is enrolled at my school under the student visa program, they're on an F1 visa, and they're enrolled in my school, do these Title IX regulations and requirements apply?
That's a great question, and I'm going to be honest. I'm not 100% sure under the way that the new regulations are crafted, whether or not they will. I know that under sort of current practice, they would be definitely considered to fall within the scope, and complaints of sexual harassment or discrimination would be addressed by institutions. But under the current, under the proposed regulations, I'm not 100% sure.
Well, I think also this is WSALA. Go ahead, Chris.
No, please.
Yeah, I think also to what Christine is saying, yes, absolutely, it's unclear. Also, the biggest focus on the U.S. persons, and I'm using the verbatim language, they say U.S. person, and it's going back to the meaning of the Title IX law, and then because it's about the programs, exchange programs, for example, right? It's about the schools, bigger universities that have programs where they send the students outside of U.S. And then when you go, let's say, on an exchange program, you're in Italy, they use the example of someone no longer being at the U.S. campus and then going to somewhere else outside of the country. But like Christine said, it's still unclear. They haven't provided direct guidance on how to manage it. And then for our school, I use our school, we would apply the current guidance, and then we have a lot of F1 students at our campus. And then if a Title IX issue would come up, we would handle it as if with anyone else.
Yeah, and I think, from an accreditation perspective, we certainly have the student complaint and grievance procedure. So regardless of what the federal regulations are in this area, I think that if a student enrolled at an ACCSE accredited institution, our expectations as the accreditor of those students are afforded the same rights to complain as any other student, regardless of kind of what the regulations might outline. And then for me as people, their type of student status shouldn't dictate to me how I'm going to treat them as a human being and how I'm going to treat them given a really complex and challenging circumstance that they might be facing at my institution.
Right, and this is where the institutional policies come to place as well, because like we said earlier, Title IX just sets the baseline. It's the minimal requirement technically, and then the institutions can have the policies that cover much broader range of complaints, and with the proposed guidance, that's probably something a lot of schools will need to look into and make sure that they cover everything.
Yeah, and that's something that I know that our schools embrace, right? We don't see a lot of mission statements that say we're going to be the most minimally compliant institution in your membership, right? So keep that in mind. Let's make sure that we have policies that are holistic to take care of our student population. Christine, one of the questions that's asked is, do you have any guidance, and this is kind of a tricky one, but what if I am an online student, or I'm a student in an online institution and I'm being harassed via chat and I'm being harassed via text? How do you know how I would apply the state regulation? Is it the state that the institution is located in? Is it the state that the student is located in? I know this is a kind of a big question. Do you have any thoughts on that?
What a great question.
I thought so too, yeah.
So now it would obviously depend on the state, but I would think that clearly the state that the institution is authorized in, their law would certainly apply, and so that would be where they're located, where their main campus is located, where they have any physical campuses would definitely the state law would definitely be triggered. And I'm trying to think of a scenario where the law of the state where the school is not located but the student is could be triggered. I think that's probably, as it applies to Title IX, I think that's a novel question. But certainly the institution's home state and the state that authorizes them, or any state that authorizes them. Obviously, institutions can be authorized by states where they're not located. So those states definitely need to be cognizant of their requirements.
Right. So for students that are participating in SARA, in an abundance of caution, what I would say to you is reach out to your state agency where you are authorized, whether it's where you're located or where the student is located, and get that practical guidance. I think that might be helpful. Here's one that I think is interesting. Another challenging question, and for either of you, Visala or Christine, when a student is off campus, but a sexual assault charge is filed by police against another student. So both students are enrolled at my institution, but the alleged assault took place off campus. Are there obligations for the school to investigate that incident?
Great question.
So under the prior guidance, I would say there definitely would be, most institutions would, and I think there would be an expectation under the prior guidance if it has the potential or the result that it is impacting the student's ability to access their education because they're sitting in the same classroom with their, assailant or what have you. Under the under the new regulations, the department was, specifically narrowed when Title IX applies, and specifically to conduct that occurs within the school's program or activity. So they didn't say that element was making a distinction between on and off campus, but it was making a distinction between conduct occurring in the school's program or activity. So under that new definition, I'm not certain that would be actionable under Title IX. Again, as we've been talking about, schools, that doesn't mean schools wouldn't address it for many other reasons, and potentially address it into their code of conduct. But I think under the new rules, it's perhaps not a given that a school would be responsible for that.
I guess, when those circumstances do arise, as unfortunate as they might be, that would be the time to really kind of flesh out what my institutional responsibilities are going to be, whether that's talking to my legal counsel, talking to my state regulator, talking to my accreditor. If formal complaints are filed, I think, at that point in the process, when it becomes a formal written grievance or complaint, schools really need to make sure that they're doing their diligence to not only abide by the law, but just to make sure that they're taking care of their students, their teachers, their administrators, and that it's not something that is brushed over or not given the attention that it deserves. It's something that they just should get all of the institution's attention when something that this significant and this serious occurs with their student body. Well, those are the questions. Let's see. Looks like I have one more question for us. Christine, do you know if a conversation starts between a student and a teacher in the classroom that doesn't raise to a formal complaint? Do you have advice, perhaps not legal advice, but for many schools, they hopefully have not had this happen at their institution. But if it doesn't go a formal route and it's more of a conversation with a student, do you have any advice for schools?
Well, I think that's definitely something that is addressed under the current regulations. So under the prior approach, that would potentially, and more likely than not, be constructive knowledge at a minimum, and faculty instructors would be considered a responsible person that should report to the Title IX coordinator. So that would be something that, yes, the school would have an obligation to escalate to the Title IX office for evaluation under the old guidance. Under the new regulations that we anticipate, now again, these aren't final yet, they haven't been released, and we don't know exactly what they're going to say. It doesn't appear that a conversation or a report from a student to an instructor would constitute actual knowledge. And that's because a report in actual knowledge only arises if that report is made to an official with authority to take corrective action. And I think it's unlikely that an instructor would be deemed to have that level of authority. Now, of course, they could certainly escalate it up the chain of command, as it were, but that incident or that instance alone, I don't think would create actual knowledge. Now, that doesn't mean that, again, as we've mentioned, these are kind of the bare minimum requirements of what is actionable under Title IX. That doesn't mean that schools shouldn't address these other issues. They should in these circumstances. And in most circumstances, they're probably going to have policies that would address all sorts of conduct and situations that aren't actionable under Title IX. So.
Yeah, so I think, a piece of advice for our institutions is if you have not done so in a while, make sure that not only you're taking a look at your own internal policies regarding student complaints and Title IX obligations, but, helpful for your team to start having these types of conversations so that, I feel like so you can establish some comfortability with, as a team, how are we going to handle a significant complaint from a student about a sexual assault or sexual harassment. And, I think sometimes when these types of situations occur at schools, they happen quickly, they unfold rapidly, and schools need to be able to mobilize to make sure that they're making that student whole. And if the first time that you're even thinking about this is when you have an incident, it might be a little late. So, and certainly encouraging schools to regularly, as part of their in-services, as part of their staff meetings, to be talking about what their expectations are of faculty and administrators for students while they're at the institution that covers sexual assault and sexual harassment, things of that nature. Well, those are all of the questions that I have. Vusala and Christine, did you have anything else for the group today?
I think Vusala can address a few additional points, yeah.
Yes, and then this is we'll cover this topic very, very briefly because just as Title IX, Clery, and WAVA have its own complexity, and it again applies just as Title IX applies to institutions that receive Title IV funding, but the requirements are slightly different. And then probably it doesn't respect Title IX, especially when it comes to the Violence Against Women Act requirement, which again was brought to us by the Obama administration. And the one big distinction I see between Title IX and Clery is the second box, is the geography piece. And we touched on this extensively during the PDC presentation, and a lot of people came up to us afterwards asking giving us very detailed examples of what would constitute a Clery issue versus a Title IX issue. So with Clery, geography matters, right? Clery focuses on your campus, public property that's adjacent to your school, and then all of the buildings that are owned by that particular school. So that is your geography. Clery space is a lot smaller compared to Title IX. However, with the new proposed regulations, up until recently, until the proposed regulations came out, Title IX's geography was massive. So, which included exchange programs, included sexual assault that may have happened outside of the campus, somewhere else at a party, two students getting together somewhere. All of that mattered when it came to Title IX. Now, the new proposed regulations trying to shrink not only the definition, but also the geography. And then that's something just we have to see what happens. But with Clery, it's very clear, very, very clear. I highly recommend for everyone to read the 2016 Clery handbook that gives you a perfect definition of each geographical requirement on how are you able to define your geography for your institution. Obviously, both laws, and they have policy statement requirements. Clery report wants the schools to describe what their prevention programs look like, what their training programs look like, and then what is their response to emergency, what is their response to any other situation that might require us to act proactively. And again, the prevention and awareness. And awareness, I can't emphasize that enough, because all of this starts with the general awareness. I will joke because I'm the Title IX for our institution. I have a funny story to tell. It's a short one. I was walking in the hallway, and then a gentleman was coming across an employee, and he basically pointed at me and he said, "Oh, you're the sexual harassment girl." And so I was excited because at least he knew who I was. He knew what my role was. It just, there's some little training that we need to do to be able to really define the role of the Title IX coordinator, and then definitions and talk about what is the definition of sexual harassment. But I was happy because the awareness is there, and I think what we ask our institutions to do is start just with that awareness. And Chris touched on that as well. Go back to your staff, go back to your administrators, and start talking to them. Review what's happening right now. Have at least a basic understanding, the knowledge of it, and see where you stand with your institutional policies. A lot of our schools actually have much more generous policies than what the fundamental guidelines of the Title IX tells us to do. And then same with the Clery. And Clery, historically, I mean, it came to us in the 1980s through a very tragic events of the young women on the left being raped and killed in her dorm room. And then her parents lobbied for a very long time to finally force the government, the Department of Education, to force the institutions to provide some kind of statistical information to those that are coming to our institutions, right? The students, the staff, employees, everyone needs to be aware of where the school stands at the moment as far as crimes are concerned. And then Clery defines crimes in a very specific way. And then I'm sure most of our schools have their annual Clery report published on their website. They distribute it to their students. So those Clery definitions are very specific. They have to be reported on. And that's something the public is looking at. That's something that the students look at. That's something that they need to be aware of to make the informed decisions when they come onto our campuses. And then there's, again, similarities in both of the requirements. Clery, WAVA, and Title IX both require institutions to have training and prevention programs. So that's the intersection. The scope obviously is slightly different, at least under the current regulations. The geography is very different under the current regulations. Reporting requirements, there's external reporting requirement when it comes to Clery, and then there could be internal reporting requirements or maybe state-related reporting requirements when it comes to both Title IX and Clery as well. And then the confidentiality is mandated by both laws. And then just to give you a quick overview of what Clery non-compliance may look like. For some of these institutions, it did not turn out really well. As you can see, last year, Michigan State had to pay $4.5 million. And just last week, my Trojan family found themselves in the big pickles with the Department of Education. We'll touch on that in a little while. But just so you know, each Clery violation, and the Department of Education recently raised this fee, equals to almost $55,000. And just our suggestion is definitely go back and then make sure that you have a good understanding of what Clery compliance means for your institution. Definitely define your geography, and then start working on your preventative policies and procedures. And of course, the notification, making sure that everybody, not just the students, but the employees, understand where they need to go when there's a concern. And they may not know the difference between a Clery concern versus Title IX concern. I think for the institutions, it's important to be able to define that reporting procedure, make it available for everybody, and then the people know who to go to. And now, to bring it all together, proactive Title IX compliance, yes, it could be very, very complicated, but at the same time, Chris talked about it extensively. Christine talked about it extensively. We have the fundamental law, Title IX. We have the state laws possibly for some of our institutions. And then that is the minimum guideline. Then we take it and we elevate it. We add our institutional policies on top of that, which is, most of us are familiar with IAIP. Those institutional policies are often working in tandem with what IAIP is. Some of us don't call it IAIP, some of us may call it something else, but ultimately IAIP is this house, right, that has all of your policies and procedures that help you manage the school, that help you to communicate with your students, and that's something that's done on at least at an annual basis. Right? You go back and you reevaluate, and these external things that happen, #MeToo movement, or Department of Education, or again, the state regulators, whenever something changes, it's a great opportunity for us to be proactive and be aware of the changes and be able to integrate them as quickly as possible. And training, we can't emphasize this enough. There's never too much training, and it's just planning it, strategizing it, and knowing, looking for the areas of risk. Where's our highest area of risk? Where do we think we lack some knowledge? Where do we think we need to create some understanding for the faculty members on how to report something, for our students on how to report something? There's the student component of the required training. There's employee component of the required training, having awareness of that, and also making sure that it's delivered on a timely basis and managed as well. Now, some of it does cost, but when we get towards the end of our presentation, we have some resources for you. Some of them are free. I would be creative. I would be very, very creative, looking for low cost or even free resources that exist out there already. I wouldn't try to create any of it from scratch, because that's a lot of headaches, it's a lot of work, and it's quite frankly confusing. I would start with existing policies that you already have and just grow upon it, and then take it from there. Maybe consult with someone, maybe look at other institutions, maybe reach out to ACCSC, and then just find a way to integrate what already exists outside into what you have already internally within your policies and procedures. And then just basically what I said, right? Your policies is what you're going to rely on when you have a concern. What your procedures, and when we focus just on Title IX, the specific grievance procedures is what you're going to rely on when you have a complaint. And under the new definitions, even though it shrinks the scope of what the report is and what the written complaint is, that's even more important for you to have that distinguished procedure written down, that everybody at your institution understands. If there's a concern, where do they need to go, and then how to report it, and then protecting their confidentiality, and then knowing that they will not be retaliated if they bring a concern to you. And prevention programs are the key, starting with the conversations like Chris said. Start with the conversation, talk to your staff, talk to your employees, maybe even talk to your students. I am positive that a lot of the student surveys will be very revealing in the areas where we might have opportunities for growth. So look at all of those different statistical or the data that exists already for you, and see where you can integrate your current policies into possibly changing what needs to be changed, and then work with your staff members to help you to develop everything. I'm rushing through all of this because I'm looking at the clock. We do need to go very quickly. And here we are, right? The resources available to you. ATICSA is an amazing organization. Their trainings are very expensive, I know. However, their website is a wealth of information, and a lot of it is actually available for free for non-members. Obviously, if you're a member, you get a much bigger library of information, but I would definitely consider going to ATICSA and looking at some policy statements, looking at procedural statements, and looking just all the existing laws, and they're staying on top of everything. They're a really, really great organization. Another really great organization is Clarity Center. We love their YouTube channel, because your YouTube channel is free. You subscribe to it, and then it just goes through step by step everything you need to do to create your Clarity report, but also stay compliant with the Clarity process, overall process, from the policy creation to dissemination and everything in between. NACIO is another great organization. Some of their information is for free, but they're mostly membership organizations, so another place to go. Chronicles of Higher Education, Office of Civil Rights, right? Always go back to the Department of Education. They'll probably have the most up-to-date information for you, at least usually. Your state resources, Max Knowledge is another great place. Max Knowledge has relatively affordable Title IX training, and then your Title IX coordinators, I'm sure they know, they have to be trained, and they have to be trained on an annual basis. Your investigators, if you have a separate investigator, which is something again being debated by the current, by the proposed regulations, But if you have investigators, they must be trained investigators. So look into all of these resources to make sure that everyone at your institution that's responsible for managing or overseeing Title IX compliance, they are trained, and then everyone they work with, they have the clear method of communication. One last thing I think we would like to end this presentation with is what happened on Thursday. And on Thursday, USC received the resolution letter from the Department of Education. So once you get this PowerPoint, you should be able to click on the resolution letter and read it. It's 51 pages. The reason why we're sharing this with you, it's quite a fascinating case. It's, I mean, be prepared to read the very disturbing and graphic details of the investigation in this resolution letter. But ultimately, University of Southern California was found in violation of Title IX. One of their employees was sexually harassing the students and employees for 3 decades. And then there were multiple complaints that came to the institution, but they didn't handle it, or they didn't handle it properly. And then ultimately, it made its way to the Department of Education, Office of Civil Rights, and the investigation started in 2018. And just last week, basically, they came up with a resolution. And one of the most important parts of the resolution is for the USC to come up with they have to overhaul their policies completely, their grievance procedures. They need to reestablish their Title IX office. They have to designate a deputy Title IX coordinator for their medical school. They have to, again, and I said it, they have to revamp their reporting process. And in addition to all of this, they need to identify any additional individuals who may have been aware of the complaints, of all the concerns in the past 3 decades and then haven't reported it. And all of this needs to be reported back to the department or the OCR by end of April. So they have a little less than 2 months for a school the size of USC, that this school has to come up with a brand new process that is compliant and meets the OCR's requirements. So I highly recommend reading this, only because it's such a great case study. It gives you an understanding of what Title IX expects from the schools, and then what is the potential outcome of non-compliance, because this is a great example of that. And I think that would be it for now. We'll turn it to Chris again. If there are any final questions or concerns or comments, we're here for another few minutes, and please bring it on.
Well, thank you so much, Vasala and Christine. Vasala, thank you for sharing the USC example. I know that you are part of that community as a student, and that it's very close to home for you, and that you challenged me last week to read that entire case study, warning me that it was powerful, and it was profound for me, clearly. So that is something that I also would recommend. It just really sets a picture, as you said, as a case study for, quite frankly, what not to do. And so, we'll be following that. I know I was reading yesterday about the hopes for a deal on reauthorization of the Higher Education Act before Lamar Alexander leaves the Senate. And as I shared with both of you, the takeaway from that article was that it really was going to come down to Title IX and whether or not they could, work out some compromise on the Title IX requirements. And so it really is kind of permeating everywhere. And, once we had a chance to hear from both of you at the PDC about this topic, about the Clery Act, about the Violence Against Women Act, this agency really wanted to make sure that we were staying ahead of some of those regulatory requirements. And right now, as Christine said, a lot of that's in flux, and it's subject to, a revised provision that we'll be all paying attention to. But hopefully for our institutions that are in attendance today, they can use this as an opportunity to really formally have a conversation with their teams about what their expectations are should they find a situation involving sexual harassment or sexual assault or violence on campus, how they want to handle those as a team. So again, I think that's about everything that we have for today. We covered a lot of ground. I thought Vishal and Christine, you both did such an amazing job. Their contact information is on the screen. You can reach both Christine and Vishal with any follow-up questions that you might have. And as I shared with you earlier, a recording of this webinar, a copy of the slides, certificates of attendance, they will all be made available on the ACCSC website. And so for any folks that did not have a chance to join us live today, they'll have a chance to participate in the recording of the webinar as well. So that's everything that I have. Christine, Vishal, do you have any other parting remarks for our group?
I just thank everyone for joining. I know there was a lot of material to cover, so please feel free to reach out to me if you have any questions.
Same here. Thank you for joining, and have a fantastic Super Tuesday.
Yeah, it's Super Tuesday, so get out there and take care of your business. On behalf of the Accrediting Commission and the professional staff here at ACCSC, I sincerely want to thank all of you for joining us for this really important session. From here, we'll just be signing off. So thanks a lot, everybody, and we will touch base with you in the near future. So thanks again.
Bye.